Hello everyone, welcome back to the channel of International Arbitration and Transnational Litigation in China. Today I want to talk about the Chinese court decision which concerns AI companion. And the problem it raises is not uniquely Chinese. A public figure discovered that an AI platform allowed users to create AI companion version of her. Users could upload her photos, use her name, set romantic or family relations, and even train the AI through emotional dialogue. And the platform did not just host this content. Its algorithms actively classified, recommended, and personalized the persona. And the Beijing Internet Court held that the platform had infringed her name right, portrait right, and general personality interest. But this case is not really about one celebrity. It raises a global regulatory question. How different legal systems control the commercial and the technological reproduction of human identity. And under Chinese law, the regulatory framework is relatively straightforward. The Chinese Civil Code recognizes a set of personality rights, including name rights, portrait rights, reputation dignity, and a residual category, general personality interests. In this case, the court treated the AI character as a virtual persona built from multiple protected elements. And the key move was not about data protection. It was about identity reconstruction. So the court said in substance, the platform did not merely use information. It recreates the functional social version of the person. And once the platform starts producing substitute social identity. So under Chinese law, the regulatory logic is AI person equals infringement of personality identity self. But English law takes a very different doctrinal route. There is no general category of personality rights under English law. Instead, the protections are fragmented, such as misuse of private information, breach of confidence, data protection, and most importantly for identity cases, passing off. By contrast, Chinese law starts from a unified concept of personality rights and treats identity as a direct object of legal protection. Under English law, passing off protects false representation, causing damage to goodwill. If an AI persona creates the impression that a person endorses, participates in, or is associated with a product or service, English court can intervene. But notice the logic. This is fundamentally different from the Chinese approach, where the legal inquiry focuses on whether a person's identity itself has been reconstructed, not whether the market has been misled. English law does not protect identity as such. It protects reputation, commercial goodwill, and the public reputation. So in the UK, an AI person becomes legally problematic, not because it violates dignity or the personality right, but because it distorts how the person is represented in the market. Identity is protected indirectly through economic and reputational harm. So compared with China, English law does not ask, has this person been duplicated, but rather has the public been deceived? So let's now look at US law. The United States goes even further in the economic direction. Most US states recognize a right of publicity, which is usually framed as a property right in one's name, image, voice, or likeness. Unlike China, which frames identity as a matter of human dignity, and unlike England, which frames it through market representation, US law treats identity itself as a form of property. So this right can be licensed, can be sold, can be inherited and enforced by estates. This is something neither Chinese personality rights nor English passing off would normally allow, because in those systems, identity is not conceived as a fully alienable asset. Courts routinely treat identity as a commercial asset in the United States. So if an AI system creates a celebrity chatbot, avatar, or companion, the legal question is the platform exploiting the commercial value of this person's identity? This is why U.S. cases focus on economic substitution, market harm, and unjust enrichment. Not dignity, not personality, but appropriation of economic value. So compared with China's dignity-based model and England's reputation-based model, the US adopts a value extraction model. So now we have three different legal languages: China, personality rights, and human dignity; England, passing off and reputational harm; United States, right of publicity as property. But in practice, they converge in one result. That is, platforms are restricted from reproducing human identity without authorization. Although doctrinal justifications differ, the regulatory effect is similar. Identity cannot be fully naturalized by technology platforms. So now, AI systems collapse the old legal distinctions. Traditionally, portrait law dealt with static images. Publicity dealt with commercial endorsements, and privacy dealt with the secrets. AI produces dynamic identity models, emotional behavior, conversational style, social relationships, and the memory and the preferences. This is no longer just image. It is a functional personhood simulation. So courts across jurisdictions are now forced to treat identity as partly personal, partly economic, and partly infrastructural. So what we are seeing globally is a structural convergence. Identity rights are becoming hybrid rights. They are enforced like a property, justified like human rights, and regulated like digital infrastructure. In other words, identity is now both economic and personal sovereignty. AI makes this unavoidable because it turns personality into a scalable technological product. So this is to conclude our discussion today. Thank you for your watching, and see you next time.